Well, hello everyone, and welcome to the latest podcast. Uh, our guest today is Nick Bacon, KC, who you all know anyway, but apart from the fact that he's probably the leading SILT in costs, he's also going to be talking about two cases in which he was involved and a further piece of reform discussion which he's involved. And I think that shows the depth of his stature, if you like, in this particular area. Talking to Nick will be the usual Andy Addis, Managing Director of Practico, and me, a consultant of Practico and former cost SILT myself. This particular session, if you've been waiting for it, has actually been put back a few times for various reasons beyond our control. We actually started planning it in March, but you'll be pleased to hear we have revised the agenda since then. But the first thing we're going to talk about is perhaps the thing which has been revised most, because it started off with Nick saying in the planning meeting, there's going to be an announcement next week, which I can't tell you about, but by the time we record next week, I'll be able to tell you all about it, which has not only happened, it's been and gone, and is no more to be seen. And that was the litigation funding agreements enforceability bill. I think that's a good place to start, so I'll invite Nick to kick off with that.
Yeah, thank you very much indeed, Jeremy and Andy. It's an absolute pleasure to participate in this podcast. I think this is my first with Practico, and I have some, if I may say so, some extremely fond memories of both you and I back in the day, litigating it out against each other. So it's very, very nice to see you. What's, as you say, the timing of this, in one sense, the delay has been helpful. The PACCAR bill, I can say with some confidence that it was literally just about there in terms of being made law. A lot of people had spent a lot of time and energy in drafting the bill, which was very short, and more importantly, in persuading others that it was the right way forward. And there seemed to be cross-party support for it. There seemed to be real enthusiasm for it, and that it would get home until Rishi Sunak decided to call a general election. And to everybody's surprise, and I'm afraid that sounded the death knell for the bill, because such was the position in relation to other, obviously, broadly speaking, more important pieces of legislation that affected the public at large, that this funding bill didn't take a priority and ended up being effectively lost in competition for other bills. And so we are in one sense back to square one with PACCAR, House of Lords decision, and nothing on the statute books to put it all right. And I have to say, obviously, the change of government, I'm very much hoping, and as I think lots of others, that the government will pick this up, the new government will pick this up and run with it and sort of pick it up from where it was left. I haven't seen a great deal from the government about that at the moment. It didn't form part of the King's speech, and that said, there are proposals for more wide-ranging reforms within the civil and criminal justice system, and I suspect this PACCAR issue will get rolled into that, which is good if it does. The only concern I have is delay, because if it gets rolled into a much wider sort of piece of reform, there'll be further debates down the line on all the other pieces of reform which will hold up this particular piece, and that's not going to be very helpful. So one of the attractive things of the last government was at least the former Lord Chancellor took a sort of a view that this was a discrete piece of work that could, form its own discrete bill and wouldn't have to be tied up with other reforms.
It was interesting that it moved, because I think originally there was talk, in fact, even a draft in a bill of something from the Department of Trade,
Yes.
which was obviously concerned about the matter. But then when it finally came forward as legislation, it was proposed by the Department of Justice, which is perhaps a more natural fit. And it was also
Yes.
more comprehensive, which
Yes, it did.
seemed to be the right way to go.
Yeah, there were all sorts of arguments about whether it could be bolted onto what were then existing bills being proposed, promulgated by the Department of Business and Trade, and that sort of went round in circles in the end, and so the decision was taken, I think, by the MOJ to and the government obviously to do what it did in the end of the bill. And there was my reading of things, and having watched and been involved in some of this, was that cross-party support was there, provided there was some serious sort of visiting of regulation. Should there be regulation of litigation funders and all the rest of it? Because early proposed amendments to that bill seemed to or wish to include provisions about regulation, and it was agreed in the end, as I understand it, that the bill wouldn't contain any proposals for regulation, but there was effectively an understanding that there would be a review of regulation, and that did happen. The Civil Justice Council, through the Master Rolls Office, has taken on that role, and I'm a party to that member of that working party. And so, as I say, it was all
that's happening anyway. I mean,
that's happening anyway.
Yeah.
So that's quite important, because that is happening anyway. So one would hope that we'd go back to status quo, that there is no need for a complicated bill about regulation. There just needs to be a bill about PACCAR, and that is relatively straightforward. So the reason this is all important is because there are a lot of cases, Jeremy, which are, many of them are CAT cases, but there are other commercial court cases which are sort of hanging around pending the outcome of this legislative sort of mess, because if PACCAR is put right, then the arguments that have been developed just disappear. If it's not put right, the arguments remain, arguments that need to be resolved by the senior courts. And the Court of Appeal last, when the PACCAR bill emerged, was very happy to effectively postpone all appeals pending the outcome of the legislative passage of the PACCAR bill, which obviously all made sense. And now that the PACCAR bill has gone, as I understand it, in the Gutman and Apple case, the Court of Appeal has recently indicated that the appeal in that, which relates to PACCAR, should continue to be stayed until further sort of notice, as it were, with the expectation that something's going to happen down the line. So I'm sure there's lots of talking at high level to get all this resolved. I mean, I hope there is. I'm sure there will be. And that,
how much was the desire to bring things forward finally by the former government triggered by Mr. Bates and the Post Office? Because Therium seems to come out of it very well.
Yes.
And therefore given, if you like, a new slant on the reputation
Absolutely.
of third-party funders, who do seem to have had a bad reputation in the past for being excessively greedy in their take.
Yeah, no.
May or not be fair, but it was certainly what was said.
Absolutely, Jeremy. It's an important slant on it, because I think it did make a difference. I think the timing of that was pretty significant, actually, because it was a working example of how litigation funding can genuinely, provide access to justice, and that those post office claimants simply wouldn't have been able to proceed without it.
Yeah.
And there was some negative press, I think, that's all been quite heavily responded to coherently, and as a consequence, there was it was a helpful sort of leg up for the bill in its passage. So and that should one would have thought continue to pervade the minds of important people who are now in charge.
In terms of, if you like, England and Wales as having a place in the litigation market, of course, the EU is looking at third-party funding in perhaps a more critical way, with a view to regulation, I think, although there's still a long way off getting anything done.
That's great.
Although you and I obviously, I think, are fans of third-party funding because it is the only way a lot of people are going to get to court. It has had a lot of negative criticism, and it's interesting to see it go ahead. That's the only reason I'm concerned that maybe this government won't have the same view, but hopefully they will.
I think it will. My sense is that there is certainly the senior. I agree with you. It is a really important adage now to the litigation regime, and they are, litigation funding is a necessary ingredient in a lot of cases to provide access to justice, and the Civil Justice Council is reporting on the need for regulation. I don't think there's any suggestion that litigation shouldn't exist. The issue is really it will exist, and so as a consequence, is there a need to have regulation of any kind, and if so, what it should look like, and not so much the principle, because the senior courts have made it very clear in a number of cases that litigation funding is an important ingredient to the modern day pursuit of claims.
Well, so it's an essential ingredient, isn't it, for some parties, and it just would not happen without it.
Absolutely. So that's where we are, and it's far too early now. The CJC's interim report is due at the end of the summer, and then there'll be a sort of wider consultation. So it's going to be a while before we get to know what's going to happen in this space in terms of regulation, if any. And but we can update people with another podcast in due course on that topic.
Yeah.
So if I could just come in there on the Gutman case itself, which you mentioned, which you were on, is that now subject to an appeal, but the appeal's been stayed?
Yes. Yeah. So Andy, there are a number of appeals in that case relating to certification, which I understand permission was refused on, but there are other appeals pending in relation to the jurisdiction of the tribunal, so inter alia, because there are other points, but the bit that I'm involved in is the jurisdiction of the tribunal to direct the payment of funding costs and other legal costs, so that could include, for example, success fees and so on, out of damages prior to distribution to the class. And that's a really important issue. There's been 2 or 3, I think maybe even 3 or 4 authorities which have held that it is possible in principle. It's obviously fact sensitive, but that there's nothing in the legislation to prevent it. But there are arguments being developed that it's not possible, and obviously that's an important issue that will be resolved.
Notwithstanding, I was quite struck by the passage in this first instance judgment, where I think they make quite a good point that if a funder can only ever get its money out of unclaimed damages and relies on a sufficiently large pot of unclaimed damages, then there's going to be a lower appetite for third-party funders, and the premiums will just become, the bounty just need to become higher to cover it.
Yeah, no, absolutely.
As a logic, that seemed to me to be very clear.
I agree. I mean, I won't say too much about the.
No, I understand.
But I agree. I mean, I think I think the idea that funders are limited to being paid out of undistributed damages plainly increases the risk for the funder. Not only have they got to win, not only have the legal team got to win the underlying claim, they then got to take on the risk of the underlying claim having a sort of balance sheet surplus of damages after distribution, and that's not easy to predict. And we all know, don't we, from the ATE days and the cost of funding and so on, that the more risky things are, the greater the premiums. And that's what happened in the ATE market when there are arguments about recoverability, and I think it's an inevitable consequence. And if that's right, then obviously there are big public policy issues about how the court should steer its way through this. It doesn't. If on the one hand it accepts the importance of litigation funding as a critical ingredient to funding, you might think it doesn't want to make decisions which, create the contrary sort of platform. So really interesting.
It gets kept out of the Supreme Court then.
Sorry, Jeremy.
Let's hope it doesn't go to the Supreme Court then.
Well, I think it's a really good point. I think it might. I think it might have to. I don't know. I hope it doesn't. But certainly I can't imagine. So if there's no PACCAR bill to put right PACCAR, then the courts will have to look at this question about whether multiples, which are sort of capped by reference to the recoveries, are DBAs, which is essentially the issue in these cases that's being stayed. I can't imagine that issue not going back up to the Supreme Court, given that the Supreme Court sort of started the problem, and I'd imagine the Court of Appeal would support the Court of Appeal's original approach. Though I don't know, it's very interesting. But I agree.
Well, if you remember back to Carey and Gray, the House of Lords, I think it was then, said they had the good grace to realise it wasn't quite the place for them to be discussing these things.
Yeah, and you're right. It may be that the Supreme Court might say, no, we're not going to look at these Gutman issues, that they should be left to the Court of Appeal and
with sense and experience.
Yeah, quite. and yeah, which might not be a bad thing, to be honest.
I'm not inviting you to agree with me in case you're in front of them next week.
No. But it's fair to say that in the competition world of opt-outs and opt-ins and certification, when you look at it holistically, sort of helicopter view, the system has been bogged down with appeals and judicial reviews and appeals after appeals, and it's not good for the business really in terms of the class, because things just get delayed. Yep. But that is the world we're in, and so that's part of the system. But as I say, everything seems to be being appealed at the moment, which I don't think overall is necessarily a good thing. And it may be that if the courts became rather more stricter in the way in which they give or grant permission to appeal, it might not be a bad thing.
Yeah. Moving on then, we spent a bit of time on litigation funding. The International Game Technology and the Gambling Commission, all about the grant of the lottery.
Yes. I've just got the authority on that. We just
It's interesting because it's a modern application of the old principle of Bolton and Secretary of State on the extent to which interested parties can recover costs independently.
Yeah,
I'm just talking over you while you're looking.
Yeah, no, I've got it. Sorry about that, Johnny. I had the authority up, and my computer I've got PDFs on different pages. Yeah, no, absolutely. It's an interesting one. It was a preliminary issue case, and the preliminary issue had been decided in favour of the defendant, with the court concluding that the claimants had no standing to challenge an award by the commission to the interested party. And there was an order for a payment on a count of costs of 2.1 million, which represented about 50% of the total costs incurred by the defendant. And there was an order sought by the interested party that their costs on the basis that an order for their costs on the basis that there were specific features of the case which justified their separate representation was justified. And there are 2 points in the case, really. I was quite interested in both of them. One was the approach to the payment on account, And the second was, as you say, the approach that the court took to the separate representation. And the court was in favour of allowing costs to the interested party on the basis that they played a legitimate role in the proceedings, had a just cause to be involved, and they should be compensated in respect to their costs. But you may or may not have the same feel for this, Andy, but Jeremy, but Andy certainly will. There was a flurry of cases, Andy, weren't there, about how to approach payments on account?
Yes.
You know,
going back to Mars and Xenon.
Going back to Mars and all the other cases, and I've marked up in here the approach that the court took was effectively 50%, wasn't it, of the
which cost. I thought was a tad generous. I thought. Yeah.
So it's paragraph 10, taking the necessary broad brush approach. So that's quite important. The senior courts are saying judges have got a very broad brush that they can apply to payments on account. He says, I've concluded that the appropriate, this is Lord Justice Coulson, wasn't it, I think?
Yes, it was.
I've concluded that the appropriate amount by way of an interim payment is 2.1 million. And he says that is essentially 50% of the total costs incurred by the Commission. I mean, no doubt that they will recover at least that sum on assessment. So it was...
Well, I have to say, how does he know?
Well, quite. But the test, though, is really now, you know, what is the sum the court is confident is going to be recovered on assessment? Does it fall for this that once you arrive at that figure, you just allow 50%?
I mean, people will argue it. I mean, obviously, I was being sort of fairly flippant about it. I find that with request for payment on account, a lot of it does depend upon the quality of the information you can put before the court.
Yeah.
And if you can go a little bit further than bald figures, and you can split it up in ways that the court will be able to appreciate, then you're likely to do better. Again, along with, you know, whether there's been whether you have any comparative information at that stage or not. So I think it would be false to say that 50% would be normal. I mean, I'd just say it's not normal to go that far in my experience. Maybe if it's a budgeted case, that might be a different matter. But I would, if this is a preliminary issue, it won't have been.
Yeah.
I don't have your feel for the current practice there, but one thing which struck me was that the judge clearly liked the defendant and the interested party and thought they'd gone out of their way to ensure there wasn't duplication and things like that. It's probably more to do with the preliminary issue, the interested parties' claim for costs. But I think if a judge likes your approach to organising your work, if you like, they're perhaps going to be more generous on an interim payment.
Yeah, I think that's probably right. So he having summarised the authorities at Excalibur and Ventures and things which we're all familiar with, he says, accordingly, I'm obliged to endeavour to identify an amount which, on any view, the Commission will recover by way of costs. And then he arrives at that figure and applies the 50% to it. So yeah. I mean, these payments on account cases, you know, I think in the end they're not. When you look at the tests in Mars and you look at Excalibur and you look at what was the other one, Pink something, they all broadly end up in the same place, don't they, Andy?
Yeah, you know? They do. Although the more you dig into, if you go back to Mars, the more you dig into it, the lower the eventual percentage seems to become. Actually,
yeah, because it was. Didn't they say it was sort of you find a figure, then you reduce that by half, then you reduce that again to reflect the fact it's an interim payment. Yeah.
Yes. Exactly. But I mean, it's probably hard to draw any real principles out of this. But it's an interesting decision with some big numbers involved.
Yeah, yeah.
At a rather different level is the case of Otto and Inner Mongolia Happy Lamb Catering Management Company Limited. I love the name.
Yeah.
And it's got no points of principle, but quite an interesting issue arose for the judge to decide.
Yeah, this was a decision of his own, Judge Matthews, who was sitting as a judge of the High Court back in December. It was a summary assessment of costs incurred on an application for an interim injunction. And there was an argument about the receiving party's hourly rate, which was claimed in excess of the guide to summary assessment of costs rates. I don't think it's necessary to sort of spell out the figures. And the issue that, the interesting issue that, Jeremy, that you identified was concerned remote working. It was suggested that the increased use of remote working meant that the geographical location of solicitors was less relevant to costs than it had been the case. And as we all know, the guideline rates are based on a geographical tabulation, and you effectively run your finger down to where the work was done, location, go across with your finger, and you get the figures. And the point was taken, well, hang on, the firm might be in Bolton or wherever it may be, but the lawyers might be at home in, somewhere less expensive geographically than the office, such that should make a difference to the recoverable rate. And in essence, the judge clearly was interested in it, because he did say later on, this may be a point for later on, but on the facts of this case, he didn't have much truck with it, and he allowed, I think, the guideline hourly rate.
Yeah. I admire the ingenuity of the argument, which is we're all working from home, so we should get a bit more than guideline hourly rate, because we haven't got those overheads. That seemed to me, I know you've characterised it much more fairly than me, but that was my very quick reading of it. I thought, that's a bit of a strange one. I'd have thought it'd be the paying party that was trying to get them down.
Right.
Yeah, exactly. I think it's helpful to the extent that it sort of foreshadows the type of arguments that you will get at some point on a heavy detailed assessment, when somebody really wants to make a big point about hourly rates, when that's really going to move the needle. And I think it's probably going to be less of a thing than we might have thought immediately post lockdown, when it looked like a very different world to the one it does. I mean, the fact is that I think, well, certainly if London's any example, people are, if you like, solicitors are going back to the office more than they were. And even if they're not, there's a hybrid form of working where there's a sort of a minimum attendance requirement. That seems to be far more the norm these days. And therefore, this is probably slightly less of an issue, or less of a demarcation than it might otherwise have been. But I mean, I think also that if we're looking at direction of travel, then I can see a way that in years to come, rates it will be just as important to classify rates by reference to the nature of the case that's being done and the work that's being done. So that, the distinction between heavy commercial and low value cases is likely to be important, I would have thought. Really, frankly, whether that work's done in a large office in Leeds, or a large office in Canary Wharf, E14, or or by people that spend 3 days a week at home and 2 days a week in the office. It's going to be neither here nor there, particularly when the more I look at rates and the way that they've been looked at, there's more of a market approach to them now anyway, rather than a cost-based approach. I don't think we're going to go back to the expensive time type calculations.
No. But the other serious point is that there are lots of firms sort of, for example, in the City of London, who've set up offices in Manchester and Leeds and other places. And the courts are now, aren't they, Andy? They're quite acute to this now, that you can't get away with a London rate if ultimately the work's all being done from the Manchester office, you know.
Yes.
And that seems to have bedded in, and so this is a sort of a little manifestation of that on the premise that there might be virtual offices. They're considered virtual offices, but it decided that it hadn't got any evidence that there was any firms anywhere that are conducting themselves virtually at the moment.
No, and there was a presumption that they had everybody's got a desk in the office anyway, which quite sure that's quite true these days, actually. There are a few firms, I think, that couldn't cope with everybody turning up on the same day. But be that as it may, I think that I think geography will be a little bit less important, I think, as time goes on. That would be my bet anyway.
We were going to conclude with the last case, which gives you both an opportunity to blow your own trumpets, the Pan-NOx emissions litigation. The thing that struck me about this judgment, and you'll tell us much more about it in a moment, Nick, was times have changed since you and I were in the county court as junior counsel, the only ones who knew anything about costs, arguing against each other for, you know, a low number of thousands of pounds. The array of counsel involved in this case for a 3-day hearing was absolutely stunning, and I thought, God, I wish I was there. And I'm obviously missing out on this.
Those are the days, hey, Jeremy?
Yeah.
It was extraordinary, actually, Jeremy, Andy. As you know, Andy, when you were part of it, that there were, you know, when you think about, as you say, when you think about where costs has come and moved in the litigation arena, it is quite astonishing that you can end up in the commercial court with literally standing room only on a cost budgeting hearing. Yeah. But you know, this is something I've been banging on about forever, as you have as well. That, you know, this case is a really good example of it. That the cases obviously are claims for damages arising out of alleged defeat devices in vehicles manufactured by a whole suite of different OEMs. But ultimately, if there is any liability, the damages are going to be modest, and the court referred to figures in the judgment. I'm not going to say too much about that. But the costs, though, are extraordinary. And this is a classic case where, you know, the costs in one sense, the costs of funding it and the costs of the litigation, you know, are, at least in terms of the economics, far more important than the damages. And it's a case where costs, where the real interest in the case is the costs, and that's why we ended up, or partly why we ended up with, and why the court tolerates plainly these sorts of hearings, because, you know, there was a claim for 350 odd million pounds on behalf of the claimants to bring these claims just to get to, you know, the second series of trials, not to bring the case to a conclusion. And the budgeting process enabled and allowed the court, effectively managing the case, to say, whoa, no, this is not going to happen, and, you know, took a swathe to the costs. But yeah, it was a remarkable hearing, and you would have enjoyed it, and as much as I did, I'm sure, Jeremy, if you'd have been around. It was. I
do remember there was an appeal. I forget the name of the case now. Shortly after Calley and Gray, on I think ATE funding, and it was one of those ones where Lord Justice Brooke wanted everyone who might have something to say to be there in the Court of Appeal. Yeah, and I was representing the TUC, and I spoke from the press gallery because there was no room.
Yes.
But that was tiny representation compared with this case.
Yeah, there were a few like that, weren't there? Yes, no, exactly. It was yeah, it was a really good thing to be part of, and I'm very pleased I was able to contribute to it.
Just yes, I suppose declaration of interest. I think that, Nick was for the defendants, or a large number of them, and Practico were instructed by, I think it turned out to be 5 of the vehicle manufacturing groups. So there were large numbers of budgets and a lot of coordination needed. I wasn't directly involved with that work myself, I am grateful to say, but it was an extremely high pressure job over a short time. I think we used to call it the adrenaline factor, didn't we, in the old days? If there is such a thing.
It was, Andy, and I think everybody on the case, certainly on our side, worked extremely well collectively together and showed their expertise vividly, in what was being done. One of the problems, Jeremy, was that there were such tight timetables, to prepare budgets, to have meetings, to discuss, the budget discussion reports. Literally, there were days, and so there was an enormous amount of work to be done in a very, very tight timetable, and it was very pressurized. In fact, Ben Williams, who was on the other side, specifically made the point that such was the enormity of the task that I think one of his cost lawyers, who's a great colleague of all of us, was unwell as a consequence of the pressures of the work that was placed upon him, and it was, in my experience, off the scale really in terms of.
And you only had to look at. Fortunately, I was doing it reflectively, the day after, but seeing some of the email traffic going on until the middle of the night, and, 2 and 3 in the morning, and then kicking off again at 7. I'm not surprised people were ill. We had a pretty. Well, they're all young compared to me on the team, but we had younger members of staff on it, and I'm just pleased to say they had the energy, and it didn't go on much longer, frankly, because otherwise I think we would have something would have given.
The other thing is with all those defendants, the main not the main task. One of the most important things to do is to coordinate and prevent duplication, and that must be really difficult to do under a tight timetable, because you just don't have to say, look, you deal with that, I'll deal with this, and all the rest of it. Have you done what we agreed, and all that kind of stuff? There just isn't time to do it, I imagine.
No, obviously the case goes on, so we can't go into sort of too much detail about working arrangements. But I think it was helpful that the manufacturer who'd been in it for the longest and had the longest run up gave a very helpful, roadmap that people could associate with. And at the end of the day, we're put under pressure, but we're also very pleased to work with very high caliber law firms. And these were very high caliber law firms who did find a way of working together extremely well and managing the difficulties of, basically they're not all in the same bucket. They do have some separate interests. That there's manufacturers, they're not one block, and that had to be managed very carefully. And that all happened, obviously away from us. That was what they had to deal with when they put the phone down or ended the Zoom call with us.
Yeah, there was a lot of coordination. It was an excellent display, I think, of how people can coordinate and get things done and not fall out, and at the same time respect the fact that there are different views being expressed within a group. And we found a way through that. We had sort of, Sandy says we can't say too much, but the council teams involved worked brilliantly together, as did the solicitor teams, and it all came together in the end. Budgeting,
it's there's more to it than that, but to reduce the claimants' budgets by, what was it, 75% overall? I mean, it wouldn't suggest to me that anybody's going to think that budgeting in extremely large cases is a waste of time.
No, quite. Well, I was really impressed by the court and the way that it got to grips with it, because I began the hearing. I think Ben, we were both agreed, we'd spoken to each other before the hearing started the night before. We were concerned about the timetable, whether we were going to be able to get through all the different budgets, because there were just so many of them. And the court made it very clear on the morning of the first morning hearing that there was no option but to get through it all. So we had to find a way, and that was excellent, because it did mean that we knew that we had to finish, and we knew that the court was effectively on side with the process. It was happy to get sort of stuck in, so to speak, in the numbers, and it did. And it had clearly, the court was clearly very well prepared, had read everything, and was ready to take it on. And Master Gordon Saker, Cost Judge Gordon Saker, together with the effectively the managing judge of the case, took away all the submissions, and in a very short period, obviously went through line by line the various budgets and arrived at the figures that they did. And it was a great display of what can be achieved in the most difficult of cost budgeting exercises. So I think you're right, Andy. For a judge now in the sort of county court who's idle and can't really be bothered in a sort of fairly standard, 2-week trial case or something, says, no, we haven't got enough time to budget. Good luck to you, because it's and that was not often. It wasn't that uncommon for such a for such a line to be taken, and you'd end up being adjourned off with no budgeting. But this case has set new standards.
Yes. It's good
to hear everything very positive about a case. I think Andy's suggestion for the next podcast will be to invite Ben along to see what his experience was like.
Actually, well, I used to know a bit about what Ben's views about budgeting were. I dare say this has reinforced them.
I think so.
But no, in fact, that gives me an opportunity to say, in fact, our next podcast guest will be Andrew Gordon Saker, and I suppose cheekily we'll have an opportunity to ask him whether he'd already decided to retire before this, or whether this was the last straw that broke the camel's back. But it will be nice to say farewell to him, because as we all know, I think he's retiring from the post in October, I think, is it?
Yes, he is, yeah.
No, I didn't know that, but so gosh.
Yes.
A new chief to take over.
Yeah, indeed. Indeed.
Presumably
we won't speculate on that. Well, certainly not with him anyway. That's good.
Anyway, look, Nick, thank you very much. It's been really interesting, a very helpful discussion with your very close knowledge of these matters, not just as a matter of law, but your, the daily doings of life at the cost bar is really helpful. And I hope that the people who are watching will see what it's like and how useful it can be. Sometimes it seems like you're sort of knocking your head against a brick wall, but a lot of the time it also actually works out in a way which is rather important for justice. So many thanks, and hopefully this session has been of interest to people who are watching.
Thank you, Jamie.
Thanks again, Nick.
And have a good summer to you both.